Good afternoon.
For Zoom, please be seated.
Good afternoon, Your Honor. I'm going to move on to the next approach that's different between the experts. That's determining relevant revenues and expenses. Ontario's submissions on this issue of defining relevant revenues and expenses are laid out at paragraphs 190 to 206 of Ontario main submissions and paragraphs 105 to 107 of our reply. I don't intend to repeat them here. Suffice to say, the plaintiff's experts and Ontario's experts took different interpretations in respect of revenues and expenses. The provisions of revenues and expenses found at paragraph 3B of the amended Court of Appeal order. I've included a copy of the provisions at tab 17, but I'm guessing we are all quite familiar with the order. So there's no need to turn it up unless you want to. Now, the drafting of paragraph 3B is very carefully done. The revenues are expressly limited to direct revenues or closely related to the lands. That restriction is not found on the expenses. It's not limited to direct expenses, and it also contains broad categories of collecting, regulating, and supporting those revenues. When I asked him in cross-examination, Mr. Hutchins told me that he did not turn his mind to this specific distinction in the wording. And that was on the cross-examination of February 21st, day 9, pages 1530 to 1531. Ontario submits that when paragraph 3B is read in a practical, logical, and common sense manner, it allows for a fair and reasonable approach to calculate NCRRs. This is the approach taken by Professors Bodway and Smart. When 3B is not interpreted correctly, it can create challenges and cause illogical results, which we have seen in the plaintiff's approach. Now let's start with the Bodway and Smart approach. The revenues included in the professor's, plural, approach are the direct Crown resource revenues. The revenue items were for the most part not in dispute. These came primarily from the trees, mining, water rentals, and the land. And that represented about 91% of all the revenues being calculated. And that is from the Bodway Smart Nominal Values Report at paragraph 35, Exhibit 60. Bodway and Smart include direct and indirect expenses related to the collection, regulation, or support of resource rents or the collection of resource rents, and exclude those that do not. And that can be found at paragraph 35 of that same exhibit 60 and page.
Can I just check one thing, please?
Of course.
Okay, go ahead.
And page 42 of exhibit 70, which was the Professor Smart demonstrative. The argument that the plaintiffs make is that Boatway and Smart include expenses that support resource rents and not direct resource revenues. They're arguing that this is not what they call a match. This argument fails because they treat those two revenue categories as somehow separate or exclusive of each other. They are not. Both Ontario experts and the plaintiffs' experts agreed that direct Crown revenues are a subset of resource rents. Direct revenues are levies drawn from resource rents. I'm going to turn court's attention to the compendium of the group of 5 oral closing submissions at tab 7. It's page 39. Put it on the screen. Okay.
Go ahead.
As you can see, Professor Stiglitz broke down the rent box, which looks gold on my copy, into subcategories. And the red slice, I guess, we can call it, is the direct Crown captured rent.
Yes.
At the next tab, tab 8, I believe this was a graph created by plaintiff's counsel. I call it the not to scale graph.
Yes.
It shows the same thing. The red bar at the bottom is the subset of the bigger orange bar or yellow. And the red bar is the rents captured through the NCRRs.
Yes.
Now, Professor Smart and Mr. Hutchings confirmed essentially the same thing. Instead of reading you a massive quote, I'm just going to point you to paragraph 107 of the Ontario reply submissions, footnote 218. So we submit, without resource rents, you do not have NCRRs.
Which is the same as NCRRs are a subset of resource rents.
That's right, that's captured by the Crown.
Okay.
Expenses that support resource rents supports direct resource revenues, or the NCRRs.
When I just asked you that last question, sir, you said as captured by the Crown. Are you using resource rents in a more limited way than the plaintiff's experts? When you say as captured by the Crowns?
I don't believe so. So the resource
Is
rents,
that a qualification of just rents in large?
so there's the, I guess, the green is the rents at large. I'm talking about the orange bar.
Okay,
And then the red bar is the subset of that. That's captured by the Crown as NCRRs.
thank you.
Okay. Yeah, so my submission was expenses that support resource rents supports NCRRs. And this is done either directly or indirectly. This is entirely consistent with the Court of Appeal amended order. How governments operate, and a practical reading of what expenses are. There is no need to judge Crown policy choices on spending. There is no need to evaluate the expectations on what amount of return will be produced or when those returns may accrue. It is also in line with common sense. And as an added benefit, this approach is workable, meaning that you can produce a model of NCRRs without having to try and trace specific purposes for each expense item, or looking for further evidence that will return 100% of your expense. And this is what Professors Bodway and Smart did. Now I'm going to turn to the approach of Mr. Hutchins next. He took his own interpretation of paragraph 3B. He talks about this on page 86 of his demonstrative, exhibit 11. I'm not going to read from it. I just wanted to give you this reference. He was generally similar on the inclusion of revenues, generally. Some exceptions included the logging tax issue, and that issue is addressed by Professor Smart at pages 40 to 41 of Exhibit 70. That's his demonstrative, where he explained that it was a tax on capital and production, not resource revenues. And another distinction is spectrum. This is addressed at paragraph 65 and 66 of the Bodway and Smart nominal values report, which is exhibit 60. And was also addressed by Canada's Council when she gave us a science lesson. Now, Hutchins' approach to expenses is addressed at paragraphs 105 to 107 of Ontario's reply submissions.
if you're not going to, I mean, it's very good of you to send me to them, but if you're not going to them now, have no doubt I can follow your table of contents to find out where these things are.
Okay, thank you.
If you're developing an argument and you want me to go to them, that's helpful.
Thank you, Your Honor. Now, Hutchins reads the expense provision as being restricted to those relating to the direct Crown resource revenues and not the resource rents generally. You can find this in Exhibit 8, page 98. I'm not taking you there.
No, but this is helpful. It's you're not sending me to your material.
Right. Now, what this does, he effectively reads in the word direct in the expenses provision of 3B, where there is none.
Hutchings effectively reads the word direct.
In the expenses provision of paragraph 3B of the Court of Appeal amended order, where there is none. Because of this, Mr. Hutchins' approach requires a determination of whether a particular expense benefits Crown revenue directly as opposed to the resource rents at large, or Crown revenue indirectly. Although he did not apply this approach consistently. An example of this is fire protection up to 1916. He includes it despite it being an indirect expense under his rules, because it supports the resource rents generally. From 1917 forward, he then excludes it for another reason based on his subsidy argument. Because of his restriction to direct expenses, Hutchins' approach takes 100% of the revenues, but does not take 100% of the expenses used to support those revenues. This approach also creates the potential need to find additional evidence to determine if an expense specifically generated direct Crown resource revenue instead of indirectly doing so.
You say because of his restriction to direct expenses, because he only includes direct expenses?
That's right. So there's an added step there. If you do something such, let's say, fire protection of a forest, under his rules, you would have to link that to direct Crown resource revenues coming back into the province, as opposed to just supporting the forest industry generally.
I'm not sure I'm just trying to look at what you've said. I'm not sure if you're getting to the point that you might recall troubled me. And I can't remember with which witness, but on the issue of fire protection, the issue that much of fire protection expense is to protect communities, not the forest industry. Are you getting to that?
I can address it right now. So there is a difference of opinion.
Yeah.
Goldway and Smart include fire protection expenses.
All of them?
Yes. I have this here. They do not second guess Crown policies. This can be classified as a but-for activity, but for the protection of the forest fires, there may not be a forest and no resource rents coming in.
Is another way of saying that one way or another, if there's a forest fire, that's a forest and it must be protected with, and the protection of it, whether because it's next door to a house or because it's exploitable for timber, generates an included expense.
Right. I can give you a more precise quote. In their opinion, expenses should be included to the extent they support resource rents, regardless of other possible benefits. And I think that's expressed at page 14, 15, and 51 of Exhibit 70, which is Professor Smart's demonstrative.
I just think after the summer we all lived through, that we might collectively think that there are worthy fire protection expenses that have nothing to do with protecting the forest and have everything to do with protecting communities.
Mr. Hutchings actually addresses that point.
Okay.
He said he cannot reliably separate the portion of fire expenses related to direct Crown resource revenues and those related to other Crown priorities. And that's at slide 144 of
He
Exhibit.
said that in response to the question, which expenses or what's the goal of fighting the fire, a fire protection expense?
Right.
And you say that because he couldn't, or sorry, Mr. Hutchings said that because he couldn't separate them, he excluded them.
Right. He said he couldn't apportion them. That's basically.
Because he couldn't apportion them, he excluded them.
That's right. So
All right.
that we don't agree on the result, but the main point that's not in dispute is that it's very difficult to say that 10% or 15%. It's to separate those kinds of.
But you make some
benefits.
comment, they're not about Goldway and Smart choose a different approach because they're not second guessing government policy.
That's
Well,
right.
are you saying they're not second guessing government policy or it's just too hard? It's just too hard to do it.
Their general position is not to second guess government policies. So if it supports the resource rents, it falls within the scope of the order.
Okay. We're not going to go on this too long, but if it protects a community and does not protect a forest that was ever planned to be cut down to generate revenue, they're saying we're just not going to engage in that exercise.
Oh, I think I know what you're saying. So there are expenses they have excluded that don't relate to resource rents, things like parks.
No,
And
I'm talking fire protection.
I know, I can't think of a specific example where that occurs. That's why I cannot say that in this district, that's what they did. So generally, they've included fire expenses, but I'm not aware of a situation where there is an fire expense that only protects non-forest assets. So you're asking me what their practices on that? I don't know
I'm
if there is
Just
one.
saying, it would be generally understood in Northern Ontario that there are fires that are identified that aren't extinguished. It's a big, big country, and there may be fires that are not close to communities that are not the subject of significant extinguishing projects.
So I'm presuming that that will be part of the, forest management or fire protection branches who are making those decisions.
Right.
Right. And they're not second guessing that. They're looking at expenses and revenues.
So they're not second guessing whether they say, here's a town. It's going to be burnt to the ground unless we extinguish this fire.
Right. Unless there's something specific in the expense that they would know to exclude it. Like I said, like park expenses or something. I haven't seen a rule that would make those kind of decisions. Mr. Hutchins doesn't stop there. He adds a second restriction to his expenses. And I'm going to call this the 100% recovery restriction. If you turn to tab 18 of my compendium,
Excuse me. Go ahead.
this is page 17 from Exhibit 70. That's Professor Smart's demonstrative, and page 51 of my compendium. He's making comment on Mr. Hutchins' second restriction, which is quoted from Hutchins' demonstrative slide 106. It's in the first bullet. And the quote is, someone would reasonably expect the incremental increase in included relevant revenues to be greater than the expected portion of the expense attributable to the relevant revenues. And Professor Smart calls this an extreme view leading to illogical results. And he gives an example below. Essentially, Mr. Hutchins requires a determination on whether an expense is reasonably expected to generate a 100% recovery by the Crown in order for that expense to be included by him. The Court of Appeal order, amended order, does not have this provision. It does not limit expenses related to the collection, regulation, and support of revenues, so long as the Crown can expect to recover 100% of those amounts. This restriction also creates a potential difficult tracing exercise on whether Crown revenues in the future can be linked to any particular expense.
But say you argue that the Hutchings approach requires that the Crown expect to recover 100% of the expense.
His rule is someone would reasonably expect. So I guess it doesn't have to be the Crown, it'd be someone.
Okay.
And building off my last point, you have to consider the time frame of the treaty. There's no end date. So if you were preventing, say, insect damage today, that might yield benefits many years into the future. Replanting trees today can produce forests 60 years from now. Would you be able to track expenses over decades to see if there's an expected recovery of that money? It could be very difficult. I have my final example for you. Imagine if you were putting on a music festival and you paid $1,000 for radio ads to increase your visibility. You pay $1,000 for the snowplow to plow your parking lot. You pay $1,000 for your lights to light that parking lot for safety, to increase visibility again. Do these items link directly to revenues? It's difficult. However, if you go to the printing store and you buy 1,000 ticket stubs for $50 and you sell those ticket stubs for $100 each at the door, that's a 100% recovery. That's not the cost of your business. This adds another layer of difficulty and unreasonableness, we would submit. What are the incremental benefits of the snowplow? The lights. This is not how expenses are normally viewed. And still, Mr. Hutchings doesn't stop there. He adds a third restriction, what I'm going to call the original or primary purpose test. If you turn to tab 19 of my compendium, primary or original, my apologies. It's tab 19, page 62. Sorry, my statement was primary or original purpose. So you can see in the, this is David Hutchings' demonstrative. I think it's exhibit 11, page 133 of his deck. And he's talking about excluding railway aid and colonization roads. And in the second bullet, he says, these expenditures are undertaken in pursuit of other objectives, such as indirect Crown revenues, resource rents, and other social benefits. So now he's judging the objectives for expenses here. When I asked Mr. Hutchins on cross-examination whether he disputes the roads and railways were used by the resource industries in the RST area, he said he doesn't dispute that. And that is at the February 21st script at page 1567, lines 16 to 22. Professor Smart gave evidence showing that the link between transportation expenses and the resource industries in the nominal values report, section 9, is IX. Which he also summarized in Exhibit 70, pages 96 to 102, which I've also included into tab 18 in the compendium. There is no purpose test found in the Court of Appeal amended order. We submit that it also requires some guessing at the purpose of expenditures or potentially requiring additional evidence to determine the purpose of any expenditure. And I remind the court that Mr. Hutchins is not an expert in any of the resource fields. We submit that he added an unnecessary requirement to the order. That is not a practical interpretation. And because of potential difficulty in determining the primary or original purpose of expenses, that approach may become unworkable in reality. It may even lead to unreasonable results, such as fixed expense ratios. The plaintiff's assertion that Professors Bodway and Smart failed to match expenses is based on their definition of expenses. For all of these issues, we submit that Mr. Hutchins' illogical approach should be rejected. My final submission issue is that the plaintiffs have made a number of assertions of errors on behalf of Professors Bodway and Smart. You can find some of these listed in paragraph 502 of their submissions at tab 20 of my compendium. Just wanted to quickly address them. So 502A, the complaint is Bodway and Smart using expenses that support rents as opposed to those that support revenues. Now, I've just addressed that in my previous submissions. B, including expenses wholly incurred outside of and unrelated to the treaty territory. There's no specifics in this one, so I'm not sure how to respond to that. I'll leave that one. C, including in reforestation expenses when the evidence did not support that any reforestation expenses were incurred within the treaty territory. And they cite to footnote 330. And footnote 330 reads, during cross-examination.
I can read it.
Oh, sorry. So what happened there was that the wrong document was put to Professor Smart in the cross-examination. If you remember, during the re-examination, I put the 1926 annual report to him, and he confirmed that that was a document that he was referring to, which contained evidence of 1925 planting efforts in the northern districts. And the sites for that are all listed at paragraph 118 of Ontario reply submissions. D refers to the logging tax. I've already addressed that. E is the slavishly treating the public accounts. I've addressed that at the start of the day. F is the 1975 report on the timber revenues. We've already addressed that. And G is a general claim failing to apportion. There's no specifics there, so I will not address that. And I take you through that just to show you the kinds of purported errors being alleged against Professors Bovay and Smart, when primarily they are not errors and possibly just disagreements between the experts. I think those are my issues, Your Honor. Do you have any more further questions for me?
I just presume you can take the corollary of your last statement.
I'm sorry, I missed that.
I presume you can accept the corollary of your last statement, where Hutching calls things errors, they are perhaps nothing but disagreements.
That's fair.
And the corollary is that where Bodway and Smart call things errors, perhaps they are nothing but disagreements.
That's fair.
Thank you.
I will end my submissions back to the question you gave me this morning about the casino and the win ratio. I will only say that when you let the casino set the win ratio, the house always wins. Thank you very much.
Thank you.
Mr. Marcello will be up next.
Thank you.
We good stuff to pass around.
Okay. Marcelo.
some Friday afternoon lawyer economics.
You're just pointing that out for me.
I will try to adhere to the first principle of physicians and at least do no harm.
What exhibit should we make this?
I think we're at 00.
Thank you very much.
The first area that I want to address is as my colleague, Ms. Barkley said, really, it's an adjunct to the Crown allocation dispute. And you can, if it helps, maybe think of it as the quantification aspect of the Crown allocation dispute. I can't think of any better way to describe it, but that's just me. I find it helpful to think of it that way. The submissions I'm going to make are alternative in nature. You have our principal submission from Ms. Barkley yesterday that this was all resolved a very, very long time ago. So the world we're in now, I would suggest as I make these submissions, the alternative world is one in which I suppose two scenarios have taken place. One would be you have rejected Canada's Section 109 argument. And you have also rejected Ontario's Award 15 and so on, res judicata argument. So we're now talking about the world of sections 111 and 112. So the first thing I want to say to you is that we have to ask what money matters in this world. What kind of money are we talking about? And I'm saying to you that the kind of money we're talking about is nominal dollars. We're talking here about the nominal dollars, the dollars of the day. We're not talking here about present value dollars. Because I say to you that if Canada had paid the annuities when it should have, and they, I believe I even heard them acknowledge yesterday or close to yesterday, I can't remember, that they're the party responsible for paying the annuities. Had they done that and made a claim against Ontario, they would have done that in the dollars of the day. They would not have done that in present value dollars. And the reason we're talking about present value dollars in this case is because Canada never paid. And so I say to you, there's no reasonable construction of sections 111 and 112 on the facts of this case that allow a court to reasonably conclude that 111 and 112 engage present dollar values. They engage only nominal dollar values. Now, the next point in this quantification box is what kind of interest are we talking about? Are we talking about simple interest or are we talking about compound interest? And we're talking about simple interest. There was historically a presumption against the use of compound interest. That goes back to the time of the BNA Act and some years after that. And Section 112 of the BNA Act is consistent with the law of the day, and it makes no provision for the payment of compound interest. And it is the governing document, the governing statute. The Mary Waldron article, which is in our compendium at tab 2, deals with some brief discussion of the law back in the day, particularly at pages 36 and 37. Compendium tab 2, pages 36 and 37. So we're talking nominal dollars in this box, and we're talking about simple interest. Third point. The simple interest point itself has been determined as a matter of res judicata. This is reflected at the third tab of our compendium, volume 3, in paragraphs 6 to 8 of the 1893 award, known now as award number 1. Third point is that there can be no indemnification requirement against Ontario, because that's what 111 and 112 are. There can be no indemnification obligation when there has been no payment by Canada. Simply put, indemnification obligations were never triggered.
All of this argument, which I have read, of course, is based on a foundation that Ontario has no distinct obligations
To pay.
Well, even distinct obligations of engagement different from the way you have described, the way Ontario has described them. Ontario has described their duty, correct me please if I'm wrong, their duty as to supply information to Canada as an on request.
So you're far from wrong. If I may say so, you're dead right.
Okay.
Yes.
So if you define that duty, as I read it, you see no duty to the Anishinaabe flowing from the obligations as a distinct emanation of the Crown. You only see an obligation to Canada, to a Crown, which,
Yes.
as best I understand it, there's no honor of the Crown duties flowing to another Crown.
That's right. We see our obligation as being tapped on the shoulder, requested for information, as it were, so that Canada could do the assessment of whether the trigger under the augmentation clause had been met.
Right. And so another way to put that is you see no duties imposed on Ontario flowing from the principle of honor of the Crown.
I don't, that is going to be addressed later. I'm not ducking you. I'm not ducking you. But I don't want you to have, you don't need any more conflicting information. So this will be addressed later. But you
But
know,
am I wrong that your arguments with respect to particularly your last point, that indemnification only gets triggered after Canada pays, is based on that foundation?
it is.
Okay. And so if you are, do you have an alternative position on simple interest and nominal dollars if that proposition is not accepted?
Well, I would, I suppose, but I don't know what the facts on the ground are that I would be dealing with.
Maybe a
So-
fairer way to put it would be, do you maintain that position if there's a finding that there's an independent obligation on Ontario flowing from the principle of honor of the Crown? The two things you say, present value and interest.
I do, unless, if I'm understanding you correctly, I do, unless you're saying that obligation would entail a requirement to make direct payment of the annuities.
You say those would be the only, unless Ontario is found to be required to make direct payment, then
Ontario,
in the relationship with Canada under section 112, there's only simple interest and only nominal dollars.
I can, if there was a direct requirement to pay, and you're not talking about 109 here,
Right.
out of that. So if there's a direct requirement to pay, I'm having trouble plugging that into 111 and 112. Which is an indemnification arrangement, right? So, which means you got to pay first, come back later, right? So then even if Canada's theory about what Award 15 meant was accepted by the court, this problem still exists because nothing more than $4 was paid. And the position I'm taking here, we're taking here, it accords with ordinary principles of commercial law too, because as you know, it's fundamental that any debtor should always be able to know the amount he or she owes in order to discharge the debt, even if the contract, that issue, like say a mortgage, had a penalty provision in it. It's still fundamental that a debtor knows what they owe. So if interest payments, even if not compounded, were accruing every year in a linear kind of way, and one wanted to pay them off, one has to know what to write a check for. And the facts of this case, that could never have been known by Ontario. 112 provides for a 5% payment, but I say 5% on what? That's another problem. 5% on what? And as it happens, Award 3, so much of this has been dealt with this issue. And I have that in the compendium at tab 4. And I refer you to paragraphs 5 and 7 there. And that's final order. Nor is there anything, as an adjunct really to the last point, nor is there anything in section 111 or 112 that provides for the payment of interest in advance of Canada having made the payment. There's no advance interest requirement, advance interest payment requirement. And that too was dealt with in the 1895 Supreme Court case. I think the appeal of Award 1, pages 498 and 499. And I just gave you the head note there at tab 5 of our compendium. Now, yet another point, which is closely related to the last one, but somewhat different, is that when we're talking about 112, we're talking about amounts of money that, as a matter of law, are unascertained.
Until
they're paid.
until Ontario gives the information on which a calculation can be based.
Until they're paid. Even, I don't know, like, something's got to be done with that information. Decision has to be made, payment has to be made, and then Canada has to come calling. I think it's in that sense that my colleague meant that Canada was a first port of call. So it's a bit of a different point than the triggering point, and there's law on this unliquidated versus liquidated amount, which used to be a real big deal back in the days of dating myself, but especially endorsed writs and so on, going way back to old Rule 33, I think it was, if Your Honor remembers that.
Triggering bad memories.
People used to strike out the writs of summons time and again, as I recall back in those days. But anyway, that's a different point. And the claim Canada makes right now has to be taken as a claim for an unknown amount. It's not ascertained. So it's not like $1,000 owed on a promissory note. It's not even like a claim for liquidated damages. Extraneous evidence is necessary, and this is really the key, to turn the unliquidated claim into a liquidated one. To date, there has been no crystallization, and the amounts at issue continue to be unliquidated. And I will, tell me if you don't want to do this, but it's quick. At tab 6 and 7, there's a couple of cases there that are kind of quick and dirties on these principles I've just mentioned. I won't read them or anything, but you can see the patent case there at paragraph 4, which is sidebarred.
Thank you.
And you can see the next tab over, paragraph 54. And the reference there to extraneous evidence being required and so on. So I just commend you to those two cases on the point. So in summary, there are a lot of problems with the claim Canada makes for indemnification on this, or well, with any claim Canada would make for indemnification. There's substantial problems. Many of them have been resolved earlier by courts, and so there's no basis for Canada to make a claim against Ontario, or there, more correctly, there's absolutely nothing. There's absolutely nothing that could be owed by Ontario by way of indemnification. There's nothing that could be owed.
Unless I think you're saying this, unless there is some independent duty imposed
And
on.
I don't want to trap myself by dancing with shadows, because I don't know exactly what that.
Or
but-
in the, or perhaps a more fair way to put it, in the absence of any duty imposed on Ontario, you say there, like, just if you put the duty aside, duty just, no duties are part of this discussion, are part of this consideration. you say therefore, or in that world, there is no ground for a claim for indemnification.
Now, we're not saying there's no duties here, but I think I would say,
That's sort of where I'm pushing you. You don't want to say that.
I'm saying whatever duties we have, they could never have been to be the payor of these annuities. They could never have been that. If you're opening up the world here to at a conceptual level to other stuff, it could never have been our requirement to be the so-called paymaster here. And there's a whole pile of reasons for that. And I'm not gonna.
And I wasn't going in that direction. Payor, I was
You,
so far in these submissions, written and oral, there has been a distinction made between the obligation to pay, a breach of the obligation to pay under the treaty, and a breach of the duties flowing from the principle of the honor of the crown. And I have specifically been asking you about the duties that flow from the honor of the crown. So when you say, in summary, nothing could be owed by Ontario by way of indemnification. And I was asking you if you say that, presuming that there are no duties imposed on Ontario flowing from the honor of the crown, not the promise to pay the treaty.
I think there could be duties on Ontario that are not requirements to pay, but that wouldn't change my analysis of how 111 and 112 work. I mean, clearly there are things Ontario says it should have done here, and it says it did not do them perfectly, and it says it did them up to standards given the context and so on. You've read all that, but I don't see any honor of the crown duty owed that would impact how 111 and 112 works. I mean, Canada could have done what Mowat and Blake did way back when. They could have paid and said, look, you guys are wrong. We're just going to increase these annuities, whatever. We're going to take a shot at it, and we're going to come at you later. And that's a different ballgame, but they didn't do that. There are a couple other points in this area. One is what I call the ratio. And this goes back to the 1870 award, and I'm not going to bore you with that anymore. I'm not saying you were bored with it. Don't get me wrong. I mean, I just don't want to repeat it because we all know the numbers. And so even within this framework here, we're talking about 52.77% of these nominal amounts, right? These actually non-existent, for reasons I've said, nominal amounts, but that ratio would be 52.77%.
And you're actually making the argument that should there be an award that nominal amounts are owed, that 48% of it should be paid by Quebec?
No.
Oh,
52.77% of it would be at Ontario's feet.
because 48% would be at Quebec's feet?
Because 48% is not at our feet.
You're not
I
working
don't
with.
know what Canada's doing with Quebec, but we know what we would owe. We know what the ratio is.
So the Anishinaabe would be out 48%. Even if there were a finding that nominal values were owed.
No, I don't think so at all. I think that our contribution would be in accordance with the 1870 award. I don't think the Anishinaabe would be out anything.
So who pays it?
Canada. So the numbers were set way back in 1870, and in the case at tab 8 in the compendium, page 816, you'll see a comment in there that to the effect that the decision made under the 142 arbitration, which is the only actual Constitution Act arbitration in the whole mix, had effectively had the same effect as if it had been in the Constitution Act. You see that comment made there by Justice Strong in the case at tab 8. Also, I will take you very quickly to tab 9, which is an easy read, quick read, where Canada, in answer to its interrogatories, and this came up, I think, with my colleague, Ms. Barkley, very briefly yesterday. The exhibit number is 98, exhibit 98. We read that in, not at the end of our case, but I think, so we wouldn't forget it, we read it in right near the end of our case. And at tab 9, you can quickly see the admission by Canada about the fact that these ratios wouldn't change as a result of subsequent events. So that's exhibit 98 at tab 9. And yet again, this ratio was confirmed.
Is this question, I'm just reading it now. Resulting ratio was not changed as a result of subsequent identification of quantification of particular pre-Confederation liabilities.
Yeah, so if this turns out to be excess debt, then that's what they're saying. They're saying it's still 52.77. And a ratio was again confirmed. This is at tab 10 of our compendium in the annuities case, the Supreme Court annuities case, the one we spent most time on in 1895, I think it was, at tab 10. So this ratio is again confirmed. And again in Award 10 in 1898. And that Award 10 confirmation is at tab 11. Now, did you want to, sure, I'll just press on until you tell me that. In terms of some arithmetic, if you look at tab 12 in the compendium, this is table 8, which was revised and appears at the back of Professor Smart's demonstratives.
Are we moving on to a new area?
No, we're closing an area.
Thank you.
Closing an area with a hypothetical in which you say I'm wrong and we're wrong and money's owed. So we had them do the math on what this was worth. And tab 8, it appeared in their original report and was refreshed at the end of Professor Smart's demonstratives. I, off the top of my head, can't remember what exhibit his demos were. I'll check. I thought it was 71, but I'm going from memory, which is getting a little tired, frankly. But we'll check that for you. Anyway, if you look at this table, you can ignore the $84 million down in the bottom right-hand corner because it's just them reminding us of what they think the annuity is worth net of the $302,000 that's been paid to date. So that's just confusing. If you put it aside, it's probably best. And then what they've done here, and I can't vouch for the math. I couldn't understand it for the life of me. The formula that they use to get these numbers, they're in Appendix E1, I think, of the present values report of Professor Smart and Bodway, E1. But if you go across the first line, you're seeing a value that reflects line, the things that go left and right. Yeah, first row from left to right. You're seeing 52.77% of the nominal amounts in excess of annuities already paid. And you're seeing.
Sorry, what am I looking at? The numbers that start with 853?
Right.
16 and 128?
Yeah, that's right. And that's the right direction. And if you're confused by why the NCR number is smaller than the other one,
Yes.
I think the answer is that just as positive numbers in the future are more heavily discounted, so are negatives to the advantage, if I may put it that way, of the plaintiffs. So the negatives in the future have less value than they would if they were closer to T1. So that's what you have in the first row, T1 being like, first point in time, right? So if you then go to the next row, that's the simple interest calculation at 5% on the numbers above.
Thank you.
And then 4C is a probably useless thing I asked them to do, frankly, which could be ignored. It's kind of got to do with when might time start to run at the earliest for interest in this case. And so it's the time of the issuance of the cross-claim by Canada.
Oh,
It's not the service date. We never could find out what the service date was. The file's been around so long, we never could dig that out. I think it's probably an inappropriate analysis anyway, but that's what it is. It's something. And the reason why the numbers are higher under the Vidal-Anderson column is because there's compounding going on there, whereas the other ones are simple interest. So that's the arithmetic or math on, if you.
sorry, they're compounding because they're in the BTA?
Yeah, they're compounded numbers on a bring forward basis, and then they're compounded within the annuities machine of Professors Smart and Bodway at BTA rates.
Right, but the reason they compound is because because that was how things worked in the BTA.
I think the reason they're compounded here is because of the way they brought the dollar numbers forward with the bond rates. If I've misspoken on that, I will correct that later. But as I said, we're talking in my submission in the 111, 112 world about simple interest at 5% on nominal amounts. And those are your first two columns there. Again, we don't say that's owed, but we say it's not owed, but we offer that for the court's assistance. I was about to say some things about economic rents. It's, try as I might, it gets dense a little bit. I'm going to try not to repeat really anything much of what Ms. Evans said. Would you like me to hit that now, or would you like to take a brief break
Oh,
now?
please start.
Okay. Our position on economic rents is contained in a wrap-up or overview paragraph, I guess. It's at page 300, paragraph 360 of our main submissions.
Sorry, I have somehow moved all of this about. Go ahead.
It's paragraph 360. Now, my friend opposite has said on more than one occasion that precision is not necessary when it comes to awarding damages or compensation. And I suppose as far as that goes as a general statement, it's true, but some very, very large numbers are being presented here, and they have an effect on anybody seeing them, I would suggest, of making smaller numbers, although very, very large themselves, seem small. And the fact that if you think and I am getting this very much from the court, that if you think whether you're doing damages or whether you're doing compensation, the precision is not the name in the game here. That doesn't mean, obviously, that in dispensing the justice to all the parties in this case, that the court should not bring significant scrutiny to bear on these very, very large numbers at play. That is tremendously important, no matter how you're framing up the task you have to do in terms of numbers. It's very, very important. It's a lot of money by any standard of judgment.
I hope I have not led anyone to think that when I say I don't intend to be reviewing these calculations, the complicated calculations, that these very significant arguments that have been made on approaches and decisions is not firmly in my mind, will not be addressed.
I'm quite sure. Thank you. So we endorse the substance of what Ms. Evans said concerning the inappropriateness of using rents and as the basis for the so-called pie to be shared, including her comments about the inherent reliability of rents.
You say inherent unreliability?
Yeah. Inherent unreliability of the rents. Thank you. We noted as well the paragraphs in the Court of Appeal that Ms. Evans did, paragraph 1D, that struck the reference of value of resources, including the land and the water. We have noted that. We think it's very important. We noted the same thing she noted as well about the agreement of the parties that the revenues in question were net Crown revenues. We endorse that. We endorse as well Ms. Evans' argument, and I will try to give you a little more granular evidence on that. We endorse her argument concerning the 30% recapture. We think there is a complete lack of cogent evidence to support that. We we do not endorse the Kersner and Booth approach. You've heard from our witnesses that they don't view how the Anishinaabe would have used the money in the same way Kersner and Booth do, and we don't endorse the Kersner and Booth approach. Now, I feel that I have to say to you that Professor Bodway's evidence in the area of rents has been, I feel, given. I don't think it's been presented fairly. And I never say intentionally. In fact, to the extent I say anything like this, take me to mean completely unintentionally. But I don't think it's been fairly.
In respect of rents, did you say?
In rents. When I say rents, I mean like this whole $126 billion thing, right? Not the net crown resources. As Mr. Hong just said, Mr. Bodway, Professor Bodway, is a renowned Canadian economist. He's a specialist in Canadian public finance, and he is an officer of the Order of Canada. And one couldn't help but notice that he was a very disarming, very frank witness. And it was clear that he was here to assist the court as much as he could. I suggest that to you anyway, and I hope you agree with that. He challenged not one reasonable proposition put to him. And he didn't go out of his way to qualify everything that he said. He tried to help. And he knows what he's talking about. And he plainly testified that the Anishinaabe did not bring rents to the table. They brought undeveloped land. And those are not the same thing at all. The Crown had to spend significant amounts of money to transform raw land into rents, into NCRs at the end of the day, or NCRRs if that's how you prefer it. His evidence in that regard is, some of it anyway, is set out at tab 14 of the compendium. Comes from day 43, May 31st. Transcript site is page 76, 19, lines 8 to 18, and 76, 21, 11 to 23. And it probably is worth a look. You're looking at it anyway, I think. I won't read it, but I will just quiet.
So what he's saying in the answer is that the Anishinaabe brought to the table unprocessed, unexploited natural resources.
That's right.
Does he say that is not rents?
Yes, he says they're not rents. What? Oh, I'm getting, Mr. Lipton is tapping his imaginary watch. I'm not sure what that means unless he's got a signal from someone that they need a break. So is that the case?
Take a break now.
Okay. Thank you.
Court is stood down for 15 minutes.
All right.
This court is resumed. Please be seated.
We had been discussing Professor's Bodway of what were and were not rents. And you had just looked at the portion of his evidence reproduced at tab 14, I think.
Yes, thank you.
So he said that, Professor Bodway said that he allowed that in a perfect world, one might estimate the value of rents. And he emphasized the perfect world when he said that beyond NCRs, but he did not interpret the Court of Appeal decision as requiring that to be done. And I hope that you will appreciate that the approach taken to the case by the economists was driven by them, not by counsel. I think Ms. Evans mentioned the fact that virtually, well, certainly the majority of economists in this case took the same approach to what the pie consisted of. And I would urge you to, because you're going to either agree or disagree with Professor Bodway's view of rents, but I would urge you to agree with him. I would urge you to agree with him. And he pointed to many serious difficulties inherent in attempting to calculate rents. These are all nicely summarized in his demonstratives. Again, I'm going to check the number for you. My team's going to have to remind me about these things. I feel like it was Exhibit 74, maybe his demonstratives. So he summarized all these problems. He pointed out rents are difficult to measure and were significantly underestimated or overestimated in this case. He talked about the impact of, production in the territory having an impact on production outside of the territory. And I think Hamal himself, Mr. Hamal, got into that too. I think the fact it's obvious, I think, that Your Honor has already recognized from some of your questions the several significant challenges that exist when one attempts to calculate the actual value of certainly of indirectly recaptured rents. I think you commented on how difficult it would be to calculate how much an investor might have been overpaid, for example, if my memory is serving me. Anyway, Professor Bodway's demonstratives, pages 27 to 58 are a kind of neat and tidy summary of his views on rents as they relate to this case. Now, Mr. Hamal, you'll recall, raised.
Sorry, did you say pages 27 to 58?
I did.
Thank you. And these are his slides.
Yes. Is it 74? Let me check that for you now in case it gets away from us. Yeah, Professor Bodway's demos are 74.
Thank you.
And Professor Smart's are 70.
Thank you.
You're welcome. So, Mr. Hamal, he raised many criticisms I would suggest are valid concerning rents as regards hydro. I'll cite you to his examination in chief on April 27th. I didn't put this in the compendium. It's day 32, pages 55, 25, line 11 to 55, 86, line 15. Mr. Hamal's demonstratives are exhibit 58. And you may have, you may recall we had a little thing about two of the slides, 40 and 41. There was an objection to him commenting on those slides. And Your Honor ruled against on Ontario on that point. And but there are many other slides in the deck that are, I would suggest, worth a look apart from those, worth a refresh. Now, my friend presented a rather expansive view of the kind of consultation he interprets the Court of Appeal to be requiring. And my colleague, Mr. Rankin, I think is going to get into this in more detail, but I would just say that consultations that engage with more than the amount of rents the Crown has collected and should consider sharing, but rather delve into how the government might change policies, or which are generally province-wide, not territory-wide, to enhance rents, very much collides with notions of fiduciary duty. And we, I think, all know what Justice Horgan said
Does it
about
collide with the absence of fiduciary duty?
that. I'm sorry?
You say it collides
Well, I mean,
notions of fiduciary duty. Are you
if-
saying it collides with the absence, the finding of absence of fiduciary duty?
yes. Yes. But despite Justice Horgan's reasons, Professor Stiglitz admitted in his cross-examination that while his reports do not use the vocabulary of fiduciary, it was one of the things he thought the court should be taking into account in how to share revenues, this whole notion of maximizing rents. And that exchange is, from his cross-examination, is at tab 17 in the compendium.
So what you have here from Professor Stiglitz is he appreciated that you're not looking at fiduciary duty.
He did, and yet he seems to think that, notwithstanding that, somehow, I don't know how else to put it, but somehow the Crown has to account for those rents that it didn't maximize. So no fiduciary duty to do it, but somehow you've got to still account to it. I can understand it. I've tried. I can understand it no other way. A very important in our submission, another very important problem with the Stiglitz approach is the rather striking admission that in calculating rents, he did not calculate or factor in, beyond recognizing it as an issue, whether or not there would be a loss to the Crown if these rents were used. And exchange on that is,
There would be a loss to the Crown if
Well, but yeah, the clause, yeah, that's right. So he's calculated these large rent values, but he didn't go through the analysis of saying, what does it mean to the case? What does it mean to, without incurring loss provision in the treaty? He didn't do that. As I understand it, he did not do that. And at tab 18, we have some more from his cross-examination in that regard. And starting around line 14, I asked him, and on your preferred sharing model, then 84% of this would be owed to the Anishinaabe, and that would be 106 billion. Question. No, the augmentation clause has a provision that's limited without loss, and I didn't calculate what that would imply. So this is just what they brought to the table. Can't see it.
Thank you.
So now to the more narrow issue, I think, of the 30% indirect capture argument. And again, we endorse, as I said, what Ms. Evans said in regard to this this point. It, to me, appears to stem out of paragraphs 329 and 330 of the plaintiff's main closing submissions, because they need a pathway in the Court of Appeal order to get there. They need a chute to bring this coal into the bin, as it were. And I think that they put a strained interpretation on the Court of Appeal order in this regard. And they say in paragraph 329, all experts agreed that resource rents are the proper conceptual basis to be used to calculate the resource-based revenues received by the Crown. And then they say this, of course, makes sense because the net resource-based revenues arising directly or in a closely related way, brackets indirectly, or in a closely related way, indirectly. To me, they appear to be using those things synonymously, closely related way and indirectly. And that just doesn't follow. That's just too broad. It doesn't follow. And it seems to be their pathway into these indirect rents, insofar as the order is concerned.
Let me see if I've got your argument. You say that the plaintiffs interpret the words in a closely related way as including the notion of indirect capture.
Yes. And I say that's wrong. The expert evidence regarding indirect recapture is, in my submission, very uncompelling. Firstly, it's referenced in paragraphs 44C and 565I in the plaintiff's main submissions. And there's no reference to any report. You produce those submissions at tab 20 just for your convenience. Next, you have the Baudouin Smart evidence that says corporate and
Reproducement tab 21.
22, sorry. It's just a copy of the paragraphs from my friend's closing submissions.
Thank you.
And then you have Professors Baudouin and Smart saying corporate and personal income taxes are not taxes on rents, but rather on capital and labor that goes into the rents. And I refer you to tab 23 and 24 in that regard, and we won't take the time to go through them, but that evidence about what corporate and personal taxes are and are not is contained there. Now, I want to be as fair as I can be to the record, which is difficult to remember. And I don't think that Professor Bodway went so far as to say there could never be some, like there can be some minor incidental capture of rents in these taxes, but that far and away is not what they're about. We'll get into that a little more later. So I think of it as, a Newfoundland fishery or something, and what they call bycatch, where, someone has a license to obviously use nets and catch mackerel. And at the end of the day, they've got a couple of cod in there and it's good for the tourists. But, it's an accident. It's sort of an inevitable thing. And they call it bycatch. And I think there might be a small amount of bycatch involved with that. And I think really that's what Professor Bodway is allowing. But that is not by any means the thrust of what is captured by personal or corporate taxes. Now, I'm not going to belabor this. I want to get you to what I think is the key evidence on this without repeating too much of what my friend said. Mr. Hutchings addressed personal income taxes anyway in his examination in chief at tab 25. We reproduced that at tab 25 in the compendium. He said he didn't attempt to calculate this share because from a practical standpoint, share of those taxes is difficult to estimate. It's difficult to estimate. And I think in particular, you'll find this at page 909 in the exchange we've produced at lines 19 through 22. 19 through 22, page 909. This stuff you can't see anything. Now, our point here is this calculation, this 30% calculation is not done in the way it's presented by the plaintiffs in any of the expert reports. And it appears to be a lawyer interpretation of numbers that were run by Mr. Hutchings. First we can see of any reference along these lines was in paragraphs 64 and 65 of Mr. Hutchings' reply report, which is exhibit 10. And with your leave, I would ask you to maybe turn it up so you can get some context on where this comes from.
Thank you. I have it.
I think if you'll permit me to just encapsulate a little bit here, I think what's going on here is Mr. Hutchings is saying, look, these guys' expenses are so high, they must relate to a lot of stuff other than net crown resources. So bring them down. I think that's the thrust of what he's saying here. But this 33% sort of concept first appears, as far as I can tell, in paragraph 65. And he's talking only there about the forestry sector. And he mentions here for the first time, at least in connection with recapture, this OECD data. And there's a website reproduced in the footnote that you might want to jump through a little bit to test the accuracy or not of what counsel are saying to you. I mean, me and Canada, hopefully verify it. but that the website is there. And I think this is the genesis of this 30-ish kind of number. And it's in the context of downstream revenues in the forestry sector. So this, this is fairly put, probably informed speculation, but I can't see any other reason any other place where Professor Stiglitz got the basis for his evidence, because he would later mention his 25 to 35% recapture when he was examined in chief, and I think when he was cross-examined as well. Now, there are some key takeaways here. I'll mention what I think they are in case my friend missed one and I'm right, or maybe, anyway, I'm just going to tell you what I think about this GDP study when you drill down. And first of all, it's Canada-wide. We can take a look at it in a second. I'm going to call it up, but it's Canada-wide. It doesn't break down numbers for Ontario. You might say, is there any reason to think they're different? The answer is, I don't know, but I'm not the plaintiff. They need to prove that these things are relevant to Ontario. The next point is it seems to apply to all industries, including resource industries.
And doesn't it say from all streams from the industries the Crown considers to be the forest
Yeah,
sector?
and there's a mention of a whole bunch of different taxes, but it's federally based, and it is.
But I'm just saying, you say it applies to all industries. That's not what they're saying.
Pardon me?
Then that's not what's said in paragraph 65. It's all industries the Crown identifies.
Yes. Yes. And that's reproduced in like the head note to the study itself. The article is, I mean, we reproduced it at tab 27, but it doesn't really do it justice, because you have to kind of click down through it to look at various things. But it's at our tab 27. Yeah. Yep, so Professor Smart, I don't know if you remember this. It's wouldn't surprise me if nobody did, but he criticized Mr. Hutchings for not performing the actual calculation of what the Crown recovered in this regard, and he did that in his demonstratives at page 91. And he pointed out that the GDP in these sectors is the return to workers and capital employed in manufacturing. Professor Smart and Bodway first addressed this point in their SIR reply report at paragraphs 53 and 54. There was, as I recall, Someone will correct me if I'm wrong. We tried to kick the tires hard on this. There was no cross-examination on these paragraphs,
These paragraphs,
53 and 54 from the SIR reply report,
thank you.
Bodway and Smart. They said their corporation income taxes are not rent taxes because they tax the capital employed in resource production, as well as the pure economic rent that's generated by the resources themselves. They said they're not even akin to rent taxes, as Mr. Hutchings would have it. Under the Income Tax Act, resource corporations have access to allowances and deductions unavailable to other companies, which largely eliminate taxes on resource rents, leaving resource rents to be taxed mainly through provincial royalty regimes. In short, corporation income taxes have been designed in Canada not to tax resource rents. And then they get more specific about the logging tax, and I'm not going to spend a lot of time on the logging tax, but they said the tax base of the logging tax explicitly included income from the forest products manufacturing, which is not a source of NCRRs. Downstream processing industries, including many forest products companies that were logging taxpayers, must be excluded from the calculations because the value they add to resources.
Mr. Marcello.
Yep.
In defense of our stenographer.
Sorry, too fast. Let me commend you to 53 and 54. Most of which I've already read apparently far too quickly. In his examination, then Professor Stiglitz would speak of a possible 25 to 35% recapture for the first time. And as I said, I can think of no other basis for where this came from other than this OECD study. We have reproduced for you that evidence, which I think Ms. Evans alluded to as well, at Compendium tab 29. A few other points in closing this issue. Even if the evidence was on point, which we say it is not, you'll note there, you can find this out quite easily. I don't think there's any contest about it. There was no OECD until 1961. And there's no other evidence offered to support this 25 to 35% figure in any other years. Indeed, many of these tax regimes weren't even in existence through most of the currency of the time frame that matters to this case. Now, I suppose one final point in this area, obviously we commend to you all our written work and so on, but one final point I want to raise here, and I want to do this because I want my friends to have a chance to clarify this. I'm not going to say I'm right about this, but I am perplexed a little bit by some of the arithmetic contained in Appendix A, not the closing compendium tab 4. Not talking about that. I'm talking about the actual appendix in my friend's closing submissions. So we have reproduced those at tab 30. I'm just going to put this out there, and my friend does, I hope not today while I'm addressing other things, but next week can say if this is correct or not, or whatever, clarify it for your honor. So I said the Stiglitz numbers didn't appear in any report. They shouldn't be given any weight. And I want to move on to this mathematical piece here, and it's really in paragraph 2C. And so 2C talks about the money award to the plaintiff should be 126 billion. And it's broken down. Rents captured directly 56. I'm just going to leave the hanging around. The rents not captured are the rents minus $56,000. So he's saying there's 69 bill, as I understand, $69 billion here is the delta between their upper bound present valued rents calculation and what was captured by the Crown. And then they go on and they say at 30%, applying 30% to 69,390 is $20 billion. And so now we have to bring that back in. So we take the $20 billion and we add it to what the Crown has already captured, the 56, and we get $77 billion. Am I going too fast?
I would like to put it in front of me and where,
Oh, I'm sorry, it's at tab 27, it's page 100. 30, tab 30, page 100.
thank you.
Well, maybe not the best time to be doing this, but
Go ahead.
so we're on the line 4, where we get the 30%, as I understand it, 30%, which is $20 billion added back in, right? And we get $77 billion. And then the submission is that 84% of that would be $65 billion. So you're getting into the joint venture model there. That's the 60. So that's where the 65 comes from.
Mhm.
But then so they're acknowledging, as I take it in line 5 here, we don't accept any of this. Well, I'll get into that, these ratios in this joint venture model, but they're accepting here, it seems that 16% of this belong to the Crown, even on their theory.
Right?
So then we go to the next line and we add back in 61 billion. And we get back to the 126. So it seemed to me that they were adding back in about $12.5 billion that they'd acknowledged belong to the Crown, even on their theory there. So it confused me a little.
Right, being the 16%.
Yes. So I could be dead wrong. But it could be confusing to your honor. If it was confusing to me, maybe not, but that's how I read it. And so my friend can address that as he will, or Ms. Lewis can as she will. Present value. You have our set list so you can follow where I am, I think.
Mhm.
This is addressed principally in our submissions in paragraph Roman numeral 4.2H, like Harold. In part Roman numeral 2.2C of our main submissions, as well as in part Roman numeral 2F in our reply. And so again, the idea here is, that the numbers should be brought forward with a 7.2 return going back way back when on the basis of this construct of a 60-40 model. And I say to you here that this is wrong. This is a measurement or purported measurement of a lost investment opportunity. This is not representative of the time value of money. Is it a different test applies to this? There's an onus on the plaintiffs to address this loss of investment opportunity within a legal framework, which boxes in which we say they do not check off. a leading case. I don't know if it's the leading case, but it's not a leading case on this. It's the one that comes up all the time as Apotex. At tab 31, we have Justice Zinn appearing again. He seems to loom large in these cases. And case of patent dispute, infringement dispute doesn't matter for my purposes. But if you could turn that up, tab 31, please. And beginning at page 106, Justice Zinn says, I agree with Justice Snyder, excuse me, I'm losing my voice too, that whether the plaintiff is relying on a specific lost opportunity or more generally on the lost opportunity to use the funds as a part of the corporate wallet, it must provide clear and non-speculative evidence to support its claim. And this is elaborated on page 107 in paragraph 51, where the court says the could have and would have are components that must be examined separately, as the Federal Court of Appeal noted in Venlafaxine at paragraph 51, because proof of one does not, I think there's a word missing there, proof of one does not entail proof of the other. Both elements have to be present. Could have does not prove would have does not prove could have. Evidence that a party would have done something does not prove that it could have done something. I might swear up and down that I would have run in a marathon in Toronto on April 1st, aiming to complete it. That says nothing about whether I could have completed it. Maybe I'm not fit enough to complete it. Evidence that a party could have done something does not prove that it would have done something. A trainer might testify that I was fit enough to complete a marathon race in Toronto on April 1st, but that says nothing about whether I would have completed it. Perhaps on April 1st, I would have skipped the marathon and gone to a baseball game instead. Sounds like me. So that the could have, would have test is the thing. It's a legal requirement. It has not been met here. What evidence is there offered in support of it? The 60-40? Firstly, there's reliance on Six Nations account number 10, which is Exhibit 75. I think my friends say it contains one reference to investments having been made for the Six Nations through the London Stock Exchange. The document is not in any expert report. It was put to Professor Bodway in cross-examination, and he knew nothing about it. Our friends called no band trust account.
Well, I thought the whole point was that there, among other things, there was a dispute as between the crowns or who had control of it and whether it was going to be disclosed or whether it should have been disclosed. So that it's not in an expert report is
It's not an expert.
it's just a fraught argument in my mind.
Okay, well,
It wasn't for the plaintiffs to find, as I recall.
okay, maybe we don't need to, we tried to have Mr. Angel address that through his slides 9 to 16. You ruled against us. It's water under the bridge. I guess it went into evidence. I guess it's in. I think I say to you, it has zero probative value. Zero. No weight, bless you, no weight should be given to it. And it particularly lacks utility given its lack of contextualization. It is hearsay. And necessity and reliability are really the principles that now underlie the law of hearsay, and rather than rigid formula. And the leading case on it, or most recent case out of the Supreme Court we could find, is Snyder. And Snyder's at tab 32 of our book. And really, I don't recall whether you admitted it provisionally or admitted it into evidence, period. I've spoken so far as if you admitted it, period. If you admitted it provisionally, I say it should not be admitted because it doesn't meet the necessity test and the reliability test. It just doesn't meet the test set out in Snyder. It doesn't help. It doesn't help your function at all. Now, I believe Ms. Evans touched on this a bit too, but I'll give you perhaps a little more in the way of evidentiary references. This was the evidence. I think this was really put forward by Group of 7 at paragraph 546F. But 546F sounds like too many paragraphs for the Group of 7, but that's what I have written down. Anyway, it's the evidence they rely on from Chief Tangi, and there's also elder evidence and evidence from Professor Driven, but I want to deal with Chief Tangi's evidence first. And I say to you that this evidence really doesn't tell the court much at all about what might have happened with treaty-wide collective annuities way back in, say, 1851 or 1881 or 1921, for a few reasons. In my submission, the record reveals that Chief Tangi was really only testifying about Michipicoten, not treaty-wide group. Secondly, she testified that between 2008 and 2012, Michipicoten was invested 100% in fixed income securities. She then said that in 2012, Michipicoten was given professional advice to invest only 35% of its money in stock. And as a backdrop, I think I recall this money was really sources back to land claim settlement. And so 35% in 2012 was the advice. And then in 2017, which I think was around the time she became the chief, Michipicoten began investing more aggressively, and they invested 60% in stocks. And she mentioned, I think, that they were required by the settlement terms to have an investment advisor. So they pushed it to 60% stocks in 2017, and they later push it, I believe she said, to 70% in 2020 when they hired AGF. And had a rate of return between 2020 and 2022 of 4.3%. So this evidence we've tried to collect for you at tab 33 of our compendium. And we say that it does not support a conclusion that there would have been a 60-40 investment of a collective annuity anywhere near in the manner, well, not at all, really, because it's all recent and it's all really just one member of the treaty-wide collectivity. So yeah, this is not supportive of our friend's contention.
Recall that the plaintiff argument is that it's hard to bring evidence of what bands would have done in the absence of the world in which they received any money. What we don't have is, and we can't have evidence of what they did with money because they didn't get it.
I think we have heard that for sure.
So that's so the plaintiffs don't say that these two pieces of evidence, I don't believe they say this, that these two pieces of evidence are the evidence alone that support their proposition.
Well, it's the evidence we see along with Exhibit 75 being advanced and some more that I'm going to come to. The historical point here too is that when there was investment in municipal bonds back in the 1849 to say 1860 period, the investments were made by the crown. They were not made by the Anishinaabe. So there's this element that, things were like they were then, and there was a heavy degree of dominion control over the Anishinaabe money then, which really did not loosen much until 1951. And then even, as my friend Ms. Evans said, not necessarily that much. So that's a thing like that. That is a historical reality. There were statutes in place, and the Hermaniskin case obviously says the government's got to follow its own statutes, and they were in place, and there was a statutory regime under which all of this took place, and under which we must, I think, conclude it would have taken place even if annuities had been paid along the lines of what our friends are asking for here. This issue of heavy dominion control would have existed, and one can debate whether it was reasons for it and so on, but it appears to be a fact that's the way it was. So I think what you're really talking about here is what might reasonably have been expected on the part of the Dominion in terms of investing. And we then get into high measures of speculation about what the Dominion might have done with collective annuities, what might have been requested of them. Certainly the pattern back then was one of pretty substantial conservatism, particularly after the Six Nations events and the changes in policy that Mr. Angel addresses in his report, which I'll touch on. I'll give you some references in a minute.
I just want to say, I think I just misspoke when I said I don't think the plaintiffs are relying only on that evidence. I meant only on that argument that there are two incidents of known investment.
Okay, I'm not going to disagree with you, but we've addressed at large the things they've said. I'm choosing here to try and focus on, in the time I have, to focus on, particular things that I think I can assist with in the time I've got.
Thank you.
The Angel report it's at the compendium tab 34. It shows the Crown investment for Michipicoten, if you want to look at that. And he addresses the change in Crown policy regarding investments that I just mentioned. He mentions that at tab 30 in his report, and we reproduced it at tab 35. Now, So moving then to a brief word on Professor Driven. His evidence was that the Anishinaabe were not interested in accumulating wealth. We cite to that evidence at the passage we've reproduced at tab 36 of our compendium. And Elder Donio spoke to the matter of Dominion control over Anishinaabe funds. I recall, give you the site in a moment, but I recall he discussed Sand River. He discussed some sawmills, a sawmill that had, I think the way he put it, had mysteriously burned down twice or something. And he was talking about the sawmill and about the efforts of the community to get money to fix things up after this, and how frustrating it was that the Dominion wouldn't allow money to be released to accommodate this wish. And we have reproduced this at our tab 37. So again, we're seeing this notion of heavy Dominion control over funds, which is a real issue when it comes to saying, well, all this money would have been, it would have been handed over, and we would have been allowed or encouraged to invest it on, I suppose, the London stock market, because I don't think there was a stock market until Montreal in 1924 here. So there's that. I move now briefly to the Anishinaabe as long-term savers, long-term investors, excuse me. And this is a point of clarification, really. The plaintiffs argue in their main submissions in paragraph 546D. They say some things about Professors Kersner and Booth there that I'm not going to speak to, but they say something there about Mr. Angel too. And they say that, I think they say that Angel said that the Robinson Superior Anishinaabe saved most of the sums they received over time. And so the implication goes, I suppose, that, they would have been able to invest in large sums of money for a very long term, and eventually get the 7.2% return rate, which is urged on the court today. But the reality is that Angel actually, his evidence actually doesn't support that. The point is overstated by the plaintiffs. First of all, as I said, it was the government managing money for the Anishinaabe, not the Anishinaabe saving money themselves. But there seems to be a conflation of the use of capital and annuity accounts as well. And I think it's known that capital accounts are generally not. Obviously, that money stays there and interest is paid out, but the capital is not paid out. That's the nature of a capital account. So I feel like there's some conflation when they say, all these amounts are being saved or maintained. There's a conflation between capital accounts and interest accounts. But Angel initially, and here's the rub on this evidence, he initially said that the First Nations spent most of the income they received. I think he basically said that. And then he walked it back. In his cross-examination, he said he'd only analyzed the accounts of Fort William and Michipicoten, and in the end, he wasn't really comfortable generalizing beyond the spending, the saving pattern of Fort William and Michipicoten, or non-saving pattern. He wasn't content that his evidence be generalized beyond that. I mean, that is the long and short of Angels. So he overstates something and he walks it back basically to ground zero. And at the end of the day, fairly looked at, I suggest his evidence does not support a pattern of long-term saving by the Anishinaabe, as our friends suggest it does. And if it leans in one direction, it leans slightly in the direction of non-saving, very slightly in the direction of non-saving. All of this is in our demonstratives, tabs 38, 39, and 40. And
Whose demonstratives are these?
this is Mr. Angel's demonstrative, slide 40.
Thank you.
There's a couple of bullet points there, which he goes off on in chief, and then he walks them back and across. So the first two bullets you want to flag as these get walked back. But as they say, they don't get walked back to the point of supporting an idea that there was, long-term saving of annuity money. One final point on this, a reference to tab 41 in the compendium, and you'll see there where Mr. Angel addresses the relevant legislation. And he says it's apparent to an historian that over a period of 110 years, 1860 to 1970, government officials had legislative authority to exercise extremely close control over the management of all monies that were deemed to be Indian monies, which term included annuities and proceeds of sales and leases of Indian lands or other property. Bottom line is what I said, is evidence doesn't support a contention that there was long-term saving. I should clarify.
This is Dr. Angel's report.
Yeah, Dr. Angel, I think didn't he say he wanted to be called Mr. Angel? I don't know. Yeah, who could remember? Anyway, I think so, but we're not saying here that we agree these are Indian monies. We don't think these are Indian monies, but the concept was these were trust accounts and they were governed by legislation. And the legislation cannot be ignored in trying to go back in history and try to formulate a view of what would have happened had these monies been paid when they should have been paid. One must take into account the realities on the ground back in the day. Now, I have another area. I can do it, or we can, I don't know what you want to do for today.
I don't, what are you telling me in time?
I'm not finishing today, whether I start this section now or not. I'm finishing Monday morning. I think I'm finishing, I'm finishing before lunch Monday, I think. I hope I'm finishing before that.
Does that mean,
Ontario finishing?
No, that's me.
did Ontario take into account that in their estimates that I ask questions from time to time? Just wondering,
Maybe not enough.
because we've had this discussion until yesterday and everybody seemed like they were maybe, where's Ms. Bark? Maybe bleeding a bit into Monday morning.
I'm hoping Ontario finishes on Monday and our friends will have a full day, or they can have more if they want.
Well, what you're, I mean, let's just be straightforward. You're not close to
I'm close.
the estimate that we heard yesterday. bleeding a bit into Monday morning is not, I hope we finish on Monday. You're taking the whole, you now say you're taking the whole day,
I think we're taking, I think.
or you would like
Unless
the
you tell
whole
us we
day.
don't have it, I think we're taking money. I think Monday, I think that, well, I mean, you're right. Maybe we didn't allow for enough questions. There were a lot of questions on that this morning. Understandably, that's our fault.
Well, I'm going
I
to
can-
ask you to look at your materials, council.
I can go later now. I can start early too.
We-
if you want.
We
I
don't
know.
have that luxury. As I said, we don't sub in
Okay,
on this
I'll,
side of the
I'll,
bed.
I'll take a look and see if I can do a, what do they call it now? More Spark Notes
More laser focused.
version.
Mr. Rankin?
Yes, Your Honor. So my original plan was to take about a half a day, but I have some homework this weekend to see if I can find some efficiencies and submissions, and hopefully I'll be able to get through the key points in less time. That would be my objective.
Let's say Ontario, you might be pushing your luck to get to lunch on Monday. How's that? You can arm wrestle for how you spend that time. It's very important for me to hear this argument and for me to have an opportunity to engage with it. But I want you to laser focus in on arguments, and you will know that from time to time I say the debate is, go to the debates and you know what they are. Let me address some questions to the plaintiffs. Where are we, counsel, if we start Monday at noon or after lunch?
Well, if we have a day and a half, I do expect we will finish on Tuesday. In fact, a day and a half is, I think, ample time for us, given what,
With Mr. Gober.
with Mr. Gober, but yes.
Mr. Bass.
Yes. I do think we will, having a day and a half, that will be sufficient. It might even be that it's an hour less than a day and a half kind of thing.
All right. Well, as soon as you say that in front of them, it's like bait to a fish. You missed that, eh?
I missed. Here's
You're
the thing.
you're being too nice to us.
Here's the thing. I mean, it would actually be helpful, and Ontario has no obligation to give me its book 4 of 4 for the weekend. But if I have it, maybe I can, the more preparation time I have, the more laser focused I can. So I encourage them to give that to me, and I don't mind sharing with them if I have any updated extra time that we can give to them if they reasonably need it on Monday. But that's up to them. I mean.
Well, I'm sure they'll think that's reasonable. It's not like you're leaking it to a witness.
Yes, Your Honor, that's no problem at all that exists. I'll just warn Mr. Shacker through you that given that I'll be relooking at efficiencies, there may well be tabs that don't ultimately become spoken to. But,
Of course.
we have no issues.
Of course. Okay, well, let's try that. I am very conscious that we don't have Wednesday. And without Wednesday, we don't have Thursday and Friday. It's just
Let's
how it
put
is.
that in stone then. I'm gonna make my plans that there is no Wednesday, Thursday, Friday.
Right. And I would like to know, what I'm hoping, I don't want anyone to make, please, a plain reservation where they have to leave at 3:32 or 4:15 or something like that. Please don't squeeze yourself like that. All right, we've got a tough enough plan as it is. So let's try that. Shall we break for the day? And I'll hear from you, Mr. Bass, after we do that. Thank you. So let's break for the day to reconvene Monday at 10. Thank you.
Thank you.
Thank you. Okay, and Mr. Bass,
This court stands adjourned until September 25th, 2023 at 10 a.m.
please have a seat.